Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. We have a busy docket for you today, so let's get straight to it. First, a bad dude is found guilty by a jury in less than 2 hours. A bank robber tries a new technique called bring a kid to the bank robbery. A mega church pastor admits his sins. A new scheduling order in the Kohberger matter. And a lawyer gets suspended because of her excessive drinking while driving. An update on the Karen Reed trial, and our dumb criminal of the day. Let's talk about it.
You, get up. Yeah, you.
All right, lawyer.
All right. Thank you, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure that you hit that little bell for notifications of when we go live or put up new content. Now, I can tell you once again, yes, Frank is still on vacation. That's why I am behind the microphone here with the headphones, running the entire Crime Talk Network command center by myself. And we're doing it. All right. So I want to thank everybody for being patient. We're getting through it. Frank will be back, I think, Thursday, and it won't be a moment too soon. Let's just put it that way. All right. So let's go ahead and, well, actually, before we get to the docket, I hope everyone had a great weekend. If you're a dad or you have a dad, hopefully you had a good Father's Day. If you didn't have your dad, you probably missed your dad. So hopefully it was still a good weekend overall. Our weekend was busy. The lovely Miss Kristen and I went to a wedding to some friends that it was a lovely ceremony. Perfect, I must say. And then, we hit the spa. We hit the spa for Father's Day. Yes, it was a good day. And that's right. Got some gifts from the kids. Some of them may have been Davidoff cigars. Can't go wrong with a good Davidoff cigar on Father's Day. All right, let's go ahead and get to the docket for June 17th, 2024. First on the docket, this guy is a bad dude. You know why he was such a bad dude? He was authorized to cover up his swastika on his face so that, the jurors wouldn't think too bad of him. Now, this is the thing more and more these days, ladies and gentlemen, as people get more and more tattoos. I think it's a generational thing, but they're everywhere. And yes, they've made their way to the face. We have had to get permission sometimes to actually have somebody come in and apply makeup, or having another attorney in the office apply makeup so that we could cover up clients that have had swastikas on their foreheads. They have written things on their foreheads, things that just aren't, things that don't instill trust and confidence in people that, hey, this guy is not a danger to somebody. So anyway, a jury found Wade Wilson guilty of killing 2 Florida women who were brutally strangled hours apart back in 2019. Now, Mr. Wade Wilson was charged with 2 counts of first-degree murder, 1 count of grand theft, 1 count of petite theft, and 1 count of burglary of a dwelling following the deaths of Christine Melton and Diana Ruiz. This goes back to, like I said, October of 2019. So Melton was found dead in her Cape Coral home there in Florida. Ruiz, a mother of 2, was found dead in an empty lot on the same day. Both had been strangled, according to police. Now, Wilson was booked into the jail on October 19th, and he was indicted later the following month in November. Now, Mr. Wilson, who was allowed, like I said, to wear makeup in court to cover up swastika tattoos on his face, did not testify during the trial, which began some 2 weeks ago. According to the district attorney, this case, there was little doubt about the killing for the sake of killing. That's what their theme was throughout the argument. Strangulation is the epitome of life slipping through somebody's hands. I cannot disagree. You know how long it takes to actually strangle somebody, ladies and gentlemen? Could take up to 5 to 6 minutes to actually strangle them. It can be bad. They can pass out a lot sooner than that, but strangle to die 5 to 6 minutes. That is the epitome of after deliberation. Apparently, though, Mr. Wilson uh, repeatedly tried to make Miss Ruiz look like spaghetti, according to the prosecutor. Anyway, both of the women died on October 7th of 2019, and both of them had been strangled, and both of them were forever silenced. The last person they encountered was Mr. Wade Wilson, according to the prosecutors. And according to the prosecutors, Mr. Wilson would have also killed his ex-girlfriend if given the chance, but there were too many people around. He instead beat her until blood splattered all over the apartment and her face. Now, Mr. Wilson's defense attorney, a woman by the name of Lee Hollander, did not deny that their client was guilty of murder, but argued that they were not premeditated and that he must have been under the influence of drugs. And she said specifically, "We're not claiming that he didn't do it. I suspect the drugs." Well, I hope you got a waiver admitting that your client did it from him written somewhere. So when they come back and later say you are ineffective assistance of counsel, you can say, no, I discussed it with my client when I admitted that he was in fact the murderer. Anyway, the attorney for Mr. Wilson asked the jury to consider convicting Mr. Wilson of second-degree murder so that the death penalty would be off the table. He said, "Hey, I'm not arguing for insanity. I'm arguing the state is claiming premeditation. I'm arguing he whacked out of his mind for any of this." The old whacked out of your mind defense. Wow. You know, if drugs and alcohol were a defense, ladies and gentlemen, I would never have a client again. No one would ever get charged again because most crime is committed while someone is under the influence of alcohol or drugs. That's right. It's not a defense, ladies and gentlemen. Now, however, there's some case law that says that you can use it to say that you couldn't form the requisite intent because you were so intoxicated. But obviously the jury didn't buy it. Apparently because Mr. Wilson had bragged about the killing to law enforcement 3 days after the murder. And the attorneys said that the biggest concern was getting a burger and fries while Miss Ruiz lay in a field with bugs eating at her face. That made her almost unrecognizable, according to the prosecutor. Now, the prosecutors said that the lesser crime shouldn't even be considered because the state has proven premeditation. Like I said, the jury deliberated for just about 2 hours before reaching their verdict, and Mr. Wilson was found guilty of all counts. The jurors will now make a recommendation to the court of whether Mr. Wilson will face the death penalty or receive life in prison without the possibility of parole. Now, the sentencing phase is going to begin on June 20th, and the state in the state of Florida, only 8 of the 12 jurors are needed to recommend the death penalty. So it doesn't have to be unanimous. So lots of states, for example, Colorado had the death penalty. You had 12 jurors. If one said life, that was it. Florida, 8 have to recommend of the 12. So I guess the state has got a chance. So we will have to wait and see. They will certainly try to get all 8, if not 12, for the court to consider that. Given the character of Mr. Wilson, I'm anticipating a death sentence. We'll keep following that. So let me know, do you think 8 is okay, or should it be unanimous in a death penalty case? Leave me a comment below. Next, a new technique for bank robbery. Yes, it's called bring a child. No one will ever know what you're doing. Well, the Dallas office of the FBI is asking for the public's assistance in identifying a bank robber responsible for a bank robbery on June 6th. So at about 2:10 p.m. last Thursday, or on June 6th, the suspect robbed the First Convenience Bank branch located inside a Walmart in Fort Worth, Texas. The robbery suspect had a small child seated in a shopping cart as he presented a note to the teller demanding cash. After obtaining the money, the suspect fled the location while carrying the child. Thank goodness the child wasn't just a prop or borrowed from somebody else. Anyway, needless to say, people were not impressed by that robber's new technique. And the police, the FBI, are looking for a white male, 35 to 45 years old, 5'7" to 5'9", thin build. He wore a baseball hat, black sunglasses, a multicolored fishing shirt, khaki-colored cargo shorts, and Hey Dude shoes. If you've seen him, you know who it is. Called the FBI office there in Texas. All right, next on the docket, a Texas pastor of a megachurch, apparently confessing his sins, not so holy, so to speak. So a woman has accused the Gateway Church pastor, a guy by the name of Robert Morris, of first molesting her on Christmas back in 1982 when she was just 12 years old. And that woman is Cindy Clemenshire. Now, she says that the abuse from the pastor continued until 1987 when she told a friend what had happened. And Clemenshire says that she told her parents after the friend advised her to do so. Anyway, guess what? I would never advise a client to do this, but on Sunday, the accused, Mr. Morris, admitted he was involved in inappropriate sexual behavior with a young lady, though he did not make any reference to the age of the young lady. He said that it was kissing and it was petting and not intercourse, but that it was wrong. He said this in a statement. And the statement says back in March of 1987, this situation was brought to light and it was confessed and repented of. I submitted myself to the elders of the Shady Grove Church and the young lady's father. They asked me to stop out of ministry and receive counseling and freedom ministry, which he did. Since that time, he has walked in purity and accountability in this area. Now, Clemenshire says she told her story for years and tried to sue Mr. Morris as far back as 2005, but her actions did not generate much attention. She says a pastor recently advised her to share her story with the Wartburg Watch, which is apparently a blog which calls attention to instances of alleged sexual abuse in churches. The website published Ms. Clemenshire's accounts of her alleged abuse, on Friday. Now, the abuse allegedly began when Morris was already married and working as a traveling evangelist. And in his early 20s, the pastor became Clemenshire's family friend and stayed with the family when he preached at their Oklahoma congregation. Then on Christmas of 1982, he asked the child into his room and groped her breast and genitalia, she said. The sexual contact escalated to sexual assault by instrumentation over the following 5 years. Now, people should not be able to do this to children or to adults and get away with it, Ms. Clemenshire is claiming. Now, Morris was pastoring Shady Grove Church back in Grand Prairie when Clemenshire told her parents what had happened in 2013. Gateway Church affiliated with the Shady Grove and made it the Grand Prairie campus. So Pastor Robert has been open and forthright about a moral failure he had over 35 years ago when he was in his 20s and prior to him starting Gateway Church. The Gateway Church elders said in a statement, he shared publicly from the pulpit the proper biblical steps he took in his lengthy restoration process. And Clemenshire says she takes issue with the elders' characterization of Morrison's restoration. He didn't come forward and confessed. He was turned in, she said. When someone is turned in, what are they sorry for? Are they sorry for they getting caught? Or are they truly repentant of what they did? Anyway, Morris returned to the Shady Grove in 1989 after 2 years of counseling. He says he resumed preaching with Clemenshire's father's blessing, but she says that did not happen. Anyway, her family forgave Morris Clemenshire, he said, but never okayed his return to the pulpit. I think leaders can get caught up, and I think it's a responsibility to protect God, but it's not. Our responsibility is to protect the people, she says. God is bigger than all of that. Anyway, Clemenshire has retained an evangelist, Billy Graham's grandson, and as her attorney. He has litigated hundreds of sexual abuse cases, because he's retained counsel. And apparently the statute of limitations for criminal or civil actions related to Clemenshire's case have likely expired, though they are exploring additional matters. Now, Clemenshire and her attorney both said that they hope her case will prompt lawmakers to consider extending or eliminating the statute of limitations for sex crimes committed against children. So why I said I would never tell a client go do this is because what if they change the statute? What if they said, hey, the statute of limitations is long expired, but we're going to create this window so you can sue people during this time period when everyone else thought it was done. It's kind of a due process violation issue, but you get the gist of it, and say, oh, now he's admitted to it. Criminal liability even potentially could be there if the legislature decided to change the statute of limitations. I think they would have to be going forward, but you get what I'm saying. So he shouldn't have said a word. Hey, it's better to look guilty than to be found guilty. Anyway, we'll see how that works out for the good pastor. Next on the docket, are we going to get something done in the Brian Kohberger matter, or are we just going to set a date to set a date? Well, that's right. We're going to set a date. A scheduling order is set for June 27th at 10 a.m. Pacific time. And the counsel in the Brian Kohberger matter, according to Judge, should be prepared to address scheduling dates, including a briefing schedule, oral argument dates for pretrial motions, including motions to suppress, motions in limine, and any motions challenging the death penalty, expert disclosure deadlines, trial settings, deadlines for filing pre-trial materials such as proposed jury instructions, juror questionnaires, witness lists, and exhibit lists. Okay, 99.99999% of the time, judges set this. They simply set a scheduling order saying these are the dates. And if the plaintiff or the defendant can't comply, then they file a motion for good cause as to why they need additional time. A judge needs to grab hold of the scheduling order, judge, and tell the prosecution, you better get your stuff in order because we're going to be setting dates. And if you don't turn over information, guess what? You're not going to be able to use it. Defense, you got a lot of people over there. I know they're working hard, but guess what? You're going to have some deadlines too to file some motions in this case. Prosecutor, you're going to have some deadlines to respond. Maybe you can file a reply brief there, defense attorneys, but we are moving this case forward. Nothing has taken place in the Kohberger matter in forever. Yeah, we've had a couple of brief hearings, but nothing has been done. Set a trial date, judge. Have you ever heard the little principle that a job expands to the amount of time given? That's right. If you set the dates, people will get it done. Attorneys are trained to comply with deadlines. They know you don't ask for extensions. You just work the hours to get it done. They will follow your orders, judge, particularly when you say there will be no extensions given unless extremely good cause is shown. All right, an unfortunate circumstance here, but it just shows you the dangers, ladies and gentlemen. And I don't know the exact number off the top of my head. I was trying to find it and I got distracted, but attorneys have one of the highest rates of alcoholism. And one of the reasons why I don't drink is simply because I come from a long history of alcoholics. And so why do it? And the other reason is I've seen a lot of good attorneys over the years completely lose their careers. So instead of having a drink when they get home, they have a couple of bad days, they have 3 drinks, and suddenly 3 drinks is the norm. And then another stressful day is 6, etc. And it just gets going and going and going. Anyway, I bring you this story not to embarrass this attorney at all, but I think it just shows you how quickly life can spiral out of control, and somebody who seemingly, has it all together, life can come apart. Anyway, the Colorado Supreme Court and the Attorney Regulation Council imposed the suspension of an attorney by the name of Denise K. And she's currently in a jail sitting down there in Arapahoe County. Now, following the suspension of her license, she'll be on probation for a period of 3 years. Now, when did all of Miss K's troubles begin? Well, back in March of 2022, when she backed into a parked police car. Yeah, that's a problem. You're going to get some attention there. Anyway, when the police noted that she bumped into their police car, they made contact with her and noticed that her eyes were bloodshot and watery, and her BAC measured a 0.298. That's about 4 times the legal limit, ladies and gentlemen, because it's 0.08 here and in most states. Well, back in October of 22, she pled guilty to driving under the influence, and the judge sentenced her to a year of probation and 3 months in jail, suspended on the condition that she successfully complete probation. So if she does everything she does, no jail. She messes it up, she goes to jail for 90 days. However, like lots of times in DUI cases, remember this, DUI case, ladies and gentlemen, and the first one can happen to anybody. You don't realize, wow, I had 2 drinks at dinner. I can't believe that put me over the limit, right? Second one, maybe you didn't get the hint. You shouldn't drink and drive, particularly in the age of Uber and Lyfts and things like that. A third, guess what? You've got a problem. And the laws generally dictate such. First, you're not going to jail. Second, yeah, you're going to jail. Third, you're really going to jail. Fourth, you're going to prison, in lots of states. Some states are even less for felonies. So 4 here. Anyway, when Miss K reported to probation several times, she was under the influence of alcohol. While on probation, she was stopped by police in August of 2022. And guess what? They suspect that she was driving under the influence. She was instructed to pull over into a nearby parking lot. And guess what? She struck the patrol car. Anyway, body cam footage was of the arrest. I'll get that up as soon as I can figure that out because Frank's not here. You know how it goes. Anyway, the officer noted, hey, you just backed into me when speaking with Miss K. Oh, I did. So you always back into police officers? The officer kind of made a little wisecrack. Anyway, the police arrested her on the second DUI charge and they put her in jail. And reported that Kay had ignored a judge's order to have an interlock device in the car, which says you can't start the car unless you blow zeros. Anyway, and then about 3 weeks later, just a couple hours after her court appearance, she was again pulled over by cops and arrested for drunken driving. This time her BAC was 0.297. Anyway, she was set to enter a plea on the 3 cases back in January of this year, but the judge rejected the plea deal, saying, he has grave concerns about the attorney's conduct. Yes, sometimes people are held to a higher standard, ladies and gentlemen, and they should be. Anyway, the judge called a recess, and when Miss K returned, she appeared to be intoxicated while in court. The judge ordered that the attorney take a breath test, and guess what it came back as? Guess, 0.324. Over 4 times the legal limit, ladies and gentlemen. Needless to say, the judge held her in direct contempt and threw her into jail for 3 days, probably 3 days to dry out. Anyway, finally, Miss K ultimately pled guilty back in February to DUI as a second and third offense. A judge sentenced her to a year in jail with 43 days credit for the time served. She was allowed to leave the jail on work release. She must also attend alcohol treatment and classes and victim impact panels through Mothers Against Drunk Driving, and her release from jail, she'll be on probation for 2 years. Now, Miss K has acknowledged that she has an addiction. I wish her the best getting through that. I truly do. And she is very thankful and appreciative that no one got hurt because of her actions. And like I said, attorney regulation determined that she violated several codes of conduct, including knowingly disobeying an obligation under the rules of a tribunal, the judge, committing a criminal act that reflects adversely to a lawyer's honesty or trustworthiness, and engaged in acts prejudice to the administration of justice. So there you go, ladies and gentlemen. Like I said, I bring you that story not to embarrass Miss K or attorneys, but to show you how quickly people's lives can turn, particularly when they have addictions. So I wish her the best. I truly do. I wish her well. But I think it's a good learning experience as well, because people that, for all intents and purposes, are supposed to have it all together, right? Attorneys are always supposed to have everything squared away, ready to go. They're human beings as well, but they're human beings with a heck of a lot more stress than most people. And it doesn't surprise me when they turn to other substances to help release that stress. Anyway, next on the docket, a Karen Reed trial update. Well, testimony of an expert with the company that the law enforcement uses to extract and analyze cell phone delivered, one could say, maybe a little blow to Miss Reed's defense team's theory of the case when he testified that the key witness made an internet search for how long it takes for someone to die in the cold. Yeah. when they discovered John O'Keefe's, the dead boyfriend's body? Yeah. Well, it was stated in court that there was plenty of evidence that there was other activity at 2:27 and also plenty of evidence that the search was made at 6:24 a.m., according to Ian Whiffen. He said that during his testimony on the 26th day of the longest case in history, yes, Miss Karen Reed, there in Massachusetts. And I say that jokingly, but ladies and gentlemen, this is a hit and run case. Most of the time, this would be 3 days anywhere where I practice. We're on day 26. Wow. Anyway, so the expert, Mr. Whiffen, a former police officer in both the United Kingdom and in Canada, he serves as the decoding project manager at Celebrite. Celebrite is the software that most law enforcement agencies use to download the phone. Anyway, he's an expert on the Celebrite in-house technology and programmer and maintainer of his own data analysis tools. Now, he is the second Celebrite expert to back up witness Jennifer McCabe's testimony that she made the search for how long to die in the cold, with some weird typos, at the behest of Miss Reed, as the woman stood over the body of the Boston police officer John O'Keefe in front of the yard at 34 Fairview Road there in Canton, Massachusetts, back in January 29th of 2022. Anyway, the defense team has said that forensic evidence points to McCabe actually making the search at 2:27 a.m., hours before Mr. O'Keefe's body would even be discovered on the lawn. And if she made the search at that time, the defense argues, it points to the conspiracy of the people in the house trying to frame Reed for O'Keefe's murder. Anyway, Whiffen's testimony matches that of fellow digital forensic expert for the defense, Jessica Hyde, the founder of and an investigator for the Bridgeport, New York-based digital forensic firm Hexodia, who took the stand last Friday. It also matches Miss McCabe's own account for that morning, as she read and another woman named Carrie Roberts discovered O'Keefe's body in the yard. She attributed that misspelling as well as the misspelling in another search of how long to die in the cold around the same time. And she said that her fingers were not cooperating in the harsh cold and that she also suffers from old multiple sclerosis. Oh, the old multiple sclerosis made you mistype it. Okay, I can kind of believe that. I can. Anyway, Miss McCabe said that her hands were frozen. She was shaking and people were screaming at her. McCabe testified during her 3 days on the witness stand. And when asked how can that data be misconstrued, both Hyde and Whiffen says there is a 2:27 a.m. marker for the search because McCabe initially opened a Safari browser tab on her phone at that time. And then McCabe said she was searching for coverage of her daughter's sports event from the previous evening on the website. And while she was lying in bed for earlier in the hours, early in the morning hours. Anyway, the data tables Whiffen presented Monday show activity on this hook'emoksports.com around the same time, and then not much else until the Google search in question. Now, Whiffen said the browser event logs are made when a program is opened, closed, or brought into focus, but there wouldn't be an event log if something is a program like Safari browser tab. It's simply moved into the background. He said the same tab was opened at 6:23 a.m. to make the initial search and then used again at 6:24 a.m. to make the similar search. Because the searches do not appear in a different history record, he believes that both searches had failed to load. Well, it raises issues, does it not, ladies and gentlemen? I think it may. Anyway, we also had Trooper Paul take the stand on Monday to continue his testimony. Defense attorney Mr. Alan Jackson, used his cross-examination to weaken the perceived expertise of the agency crash reconstruction examiner. Paul agreed that he didn't have any degrees in mathematics, physics, engineering, or any other STEM field, And Jackson asked him about all that, and he has an associate's degree in criminal justice. Doesn't mean he can't do the math. Anyway, it was painful testimony. I was watching it. Painful testimony. Anyway, so the defense attorney, Mr. Jackson, poked holes into Mr. Paul's analysis on the scene, and he pointed to a piece of debris that looked like a taillight material found near the fire hydrant that wasn't included in Mr. Paul's description of the following debris field to determine a point of impact. Mr. Paul said that he never said exactly where the point of impact was, but that he followed the path of debris in a linear way to find the likely point of impact on the roadway. While Mr. Jackson challenged whether Paul's testimony on Friday was so vague about where the crash actually occurred. The truth is, Trooper Paul, you don't really know what any of these physics calculations actually mean, do you? Anyway, the court sustained that objection. I don't know. It goes on, ladies and gentlemen. We got to be getting close. The Karen Reed case, we got to be getting close. Hang in there. We're almost there. And finally today, our dumb criminal of the day. That's right. Unbelievable, ladies and gentlemen. Just when you thought it was over, more food crime. Please meet Andre Eason. Mr. Eason and his victim, they were in a car Friday when about 4 a.m. Apparently they live in a hotel, but they were just outside of a Walmart at 4 a.m. at a supercenter in St. Petersburg, to be exact. And apparently an assault broke out involving a honey bun. You all want to know what the honey bun, the little sticky buns like a cinnamon roll with the stuff on top, sticky bun, a sticky bun attack. Well, it was alleged that Mr. Eason allegedly smacked the victim in the face with the sticky bun, causing minor redness. Needless to say, Mr. Eason was arrested for domestic battery, which is a misdemeanor. He was released from custody in order to have no contact with his girlfriend for 6 months. The couple's relationship, however, began roughly after Eason was released from prison earlier this year. And according to the court records, he described in court as self-employed. Self-employed, and which previous self-employment may have included the sale of fentanyl and methamphetamine, which resulted in his previous prison sentence, which would explain why he was just recently released. Anyway, ladies and gentlemen, food crime. It never ends. It never stops. It always goes on. It always goes on. And I think the way the food is involved is because you really want to disrespect somebody. Don't just, tell them off. No, you throw food at them. And I'm not saying that you should do that. I'm not. But there's never a shortage of dumb criminals and food crime. All right, ladies and gentlemen, that's all we have for you today. I hope you enjoyed the show. Like I said, Frank should be back soon. We'll have all the fancy color pictures up. Yeah, I just didn't have time to do that. My apologies. Anyway, I want to thank you all for watching. Like I said, hope you had a great Father's Day out there, or wished your father a good Father's Day. If they're still with you, I hope they are. And remember, tomorrow night, 6 p.m. Mountain Time, we do our live show as well. And then our Patreon show immediately following that. So if you haven't become a Patreon now, would be a good time to do so. Anyway, so have a wonderful day. We'll see you next time. And yes, remember, the Constitution matters. The Constitution matters.